which the Geo cites is a judgment again of the Kerala High Court, which your lordships will find in item 6, which is at page 39. Also note one interesting thing, my lord. This judgment is authored by the same learned judge, my lord, Justice Mushtaq, who also authored, my lord, that earlier judgment which I cited, upholding wearing of, my lord, headscarf as an essential part of Article 25, my lord, when it came to the question of those girls, my lord, in a CBSE setting. Now, my lords, this case, my lord, the learned judge was faced with a situation where, my lord, a minority institution, my lord, came. The question was whether a Muslim girl can enforce this right qua a Christian minority institution. Please see page 39, respondent number 4 and 5. This was, my lord, the principal Christ Nagar Senior Secondary School, and please see 5, manager Christ Senior Secondary School. So the context, the text and the context of the judgment is primarily dealing with the rights of a minority educational institution vis-a-vis Article 25 right. And the court says a minority educational institution's right to administer institutions of their choice or admit students is paramount. It will override Article 25 right. Just have a look at, my lord, page 39. Religious dress in a private educational institution is an issue in this writ petition. So the state can't rely upon it, my lord. Today the GO doesn't apply to minority institutions. The GO applies to government institutions. So therefore, my lord, my submission is that reliance upon
private.
Yes, my lord. Then, my lords, may kindly see. I'm sorry, my lord.
The issue is not the minority institution, private educational institution.
No, it's private educational institution, which is a minority, my lord, because the court notes this. And I'm grateful for that question. Just have a look at, my lord, first para 3, my lord. A private educational institution doesn't have a higher right, my lord, than a normal institution. It's only a minority institution which has a right under Article 30, which your lordships are aware. One has the liberty to follow his own notions and convictions in the matter of dress code. At the same time, when such a right is claimed against a private entity, which is also having equal fundamental right to manage and administer an institution, that your lordships are aware, my lord, of Article 30. If I can just place Article. Lordships will see Article 30, my lord. Lordships will just have a look at Article 30. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. So this was a Christian minority institution. And then, my lords, in paragraph 4, that earlier judgment is noted. And then, my lord, see what the court says. The right, paragraph 5. The right to establish, manage and administer an institution is equally a fundamental right. Fundamental right is traceable to Article 19, of course subject to reasonable restrictions. TMA Pi, PA Inamdar, all these judgments are cited, and ultimately in paragraph 10, the court says, page 41, in such view of the matter, I am of the considered view that petitioners cannot seek imposition of their individual right
Yes.
Yes, my lord. Para 41, page 41, my lord. In such view of the matter, I am the considered view that the petitioners cannot seek imposition of their individual right as against the larger right of the institution. It is for the institution to decide whether the petitioner can be permitted to attend the classes with the headscarf or not. Correctly, absolutely correct, my lord. Constitutionally, private minority educational institutions can't be, my lord, foisted with, my lord, students whom it doesn't want to admit. Number one. And, my lord, as far as headscarves, etc., these are matters which will be prescribed by the standards, will be prescribed by that institution itself. That freedom is there in the Article 30. The next judgment, my lord, which the GO cites, is a Bombay High Court judgment.
Mr. Kamath,
I'm sorry, my lord.
sorry for the interruption.
Yes, my lord.
Retrace your steps.
You should not be sorry, my lord. It's an opportunity to understand.
Yes, very well. Yes. You quoted the High Court judgment which had referred to the decision of the apex court of an Islamic country,
Yes.
which held wearing hijab is an essential religious practice of Islam. Do you have any other courts of any other Islamic countries apart from other secular countries where they have taken a divergent view on this?
My lords, as far as my research so far goes, my lord, I have not been able to find out, my lord, any authoritative verdict which has taken a contrary view as of now, my lord. But I stand corrected. Lords, I am not the sole repository of all knowledge. My lord, as of now, my research shows, my lord, that as far as this headscarf is concerned, there is no authoritative pronouncement by any court saying that it is not a part of essential practice of Islam. As of now, I can say that. Now, my lord, the second judgment which the GO cites is AIR 2003 Bombay 75, which is the first judgment, my lord, in the compilation. And this again, my lord, I respectfully submit, doesn't actually help the state government, because this was rendered in the context of a all girls section, and therefore, my lord, the injuncts which are there in the Islamic faith, that you shall not show your head, etc., to a member of the opposite sex, those will not be violated in an all girls section. And that probably, my lord, weighed with the honorable court, which I want to show at page. Not wearing the headscarf or head covering, studying in exclusive girls section, cannot be said to in any manner acting inconsistent with verse 31. It is not an obligatory overt act enjoined by Muslim religion that a girl studying in all girls section must wear head covering. Lords, I need not cite authorities on this, but your lordship's court have time and again said that judgments cannot be read as Euclid's theorems, my lord. It has to be seen in the text, it has to be seen in the context, my lord, of the facts which were there before the court. And both these judgments which the GO cites, one minority educational institution, one all girls section, doesn't apply, my lord, in our case. And the third judgment, my lord, which the GO cites, is a Madras High Court judgment, which your lordships will find, my lord, at page 4. This has nothing to do with Article 25. I'm quite surprised, my lord, that the state chose to rely upon this judgment. This judgment, my lord, I will not trouble your lordships, but lordships may make a note. This judgment, there is not even one word on Article 25. There is not even one word on headscarf. This was a case where the government prescribed uniforms for teachers. And under that educational act, whether that was permissible or not, whether under the contract with the teachers, the government could enforce a uniform, that was the issue. Nothing to do with Article 25. And the GO says, with respect, that these three decisions show that Article 25 says that headscarf is not covered under Article 25. I respectfully submit, my lord, this is a fatal error. Number one. Now, my lords, with this, Lords, I go to my first, my lord, Supreme Court judgment, which your lordships will find, because the GO says we have considered Supreme Court judgments, High Court judgment. There are no Supreme Court judgments in any of this. Now, the Supreme Court judgments which are actually applicable are these. First, lordships will turn to the Shirur Mutt case, which your lordships will find at page 42. Lordships are aware, my lord, the facts of this case. A scheme was sought to be, my lord, imposed, and the Mathadipati objected. And in that context, my lord, kindly see page 50, where I am saying that a dress prescription can also be a part of Article 25. Just have a look at, my lord, page 50. It starts at page 42. Page 50, about paragraph 17, my lord. I'll not trouble your lordship with the entire paragraph. The last about 4 lines of paragraph 17. It starts with, there are well-known religions in India. My lord, the Chief Justice got it?
Yes.
Yes. There are well-known religions in India, like Buddhism and Jainism, which do not believe in God or in any intelligent first cause. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess the religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine of belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe rituals and observances, ceremonies and modes of worship which are regarded as integral parts of religion, and these forms and observances might extend even to matters of food and dress. This is what, my lords, I wanted to place for my lord's consideration. So the dress, my lord, is also a part of a religious practice, and this is not what I say, my lord. This is what the Supreme Court settled way back in 1954. The next judgment, my lord, which I want to cite is Ratilal Gandhi. Page 67, it starts at page 63. And this was again a case of a, my lord, Jain trust. And whether, my lords, certain sections of the Bombay Public Trust Act, which took away the certain powers of those trusts, my lord, were legal or not, and certain sections were struck down, saying that it was contrary to Jain religion. And in that context, my lord, just have a look at just one page, my lord. Page 68. No outside, sorry, top of that page, page 68. Page 68. No outside authority has any right to say that these are not essential part of religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner they like, under the guise of administering the trust estate. Not the proposition which I am canvassing is this: the state is an outside authority. It cannot give an authoritative pronouncement on whether wearing a headscarf is an essential part of religion or not. It has to be looked at, my lord, from the point of view of the believer, of that person who professes that faith. Lords, Lords, as a citizen, as a counsel, as an officer of your lordship's court, I may not agree with the headscarf at all. I may personally think it is very regressive. I would think, my lord, that everybody should have a same uniform. But it is not for me, my lords. And for that matter, for your lordships also. Because that is what the Supreme Court says in Vijay Emmanuel, that it is not for the court to sit in judgment. It is to be looked at, my lord, from the point of view of the believer. And that is why, my lord, that Vijay Emmanuel's Justice Chinnappa Reddy's judgment is written so beautifully, my lord, which encapsulates our secular ethos. Just have that judgment, my lord, page 75. Starts at page 75. And if we just replace, my lord, The facts of this case, that is wearing a headscarf innocuously, not disturbing anybody, going to school or a college, just have the same facts, my lord, transpose it to this case, and how kindly see how this case fits on all four. And I respectfully submit there is nothing else to be seen, my lord, in this case is concerned. This is totally covered by BJ Emmanuel on all counts. Just have a look at the judgment, my lord. Starts at page 75, page 79, my lord. The facts. As a citizen, my lord, I will not agree. Why should a student not chant or sing the national anthem? But the court said it's their right. They are not creating a hindrance to anybody. The constitution has permitted them. Just have a look at that page 79, my lord. 3 child applicants, Bijo, Mino Mall, and Bindu Emmanuel, are faithful of Jehovah's Witnesses. They attend school daily during morning assembly. When national anthem Jana Gana Mana is sung, they stand respectfully. I'm sorry, my lord, the Chief Justice got. Yes, ma'am. When national anthem Jana Gana Mana is sung, they stand respectfully, but they do not sing. They do not sing because according to them, it is against the tenets of their religious faith. Not the words or the thoughts of the anthem, but the singing of it. This day and before them, their elder sisters who attended the school earlier have done all these years. This is very important because that's the question which the Honorable Chief Justice asked me, whether they have been doing this all these years. And I say yes, in the writ petition paragraph 6. But now continuing, my lords, no one bothered, just see this, my lord, no one bothered, no one was worried, no one thought it disrespectful or unpatriotic. The children were left in peace and to their beliefs. That was until July 1985, some patriotic gentleman took notice, in this case the state, on 5th of February. The gentleman thought it was unpatriotic of the children not to sing the national anthem. He happened to be a member of the Legislative Assembly. So he put a question in the assembly. A commission was appointed to inquire and report. We do not have the report of the commission. We are told so and so, my lord. Then, my lord, they were expelled from school. And then paragraph 3, they went to court. Paragraph 3, my lord. That the petitioners truly and conscientiously believe what they say is not in doubt. They do not hold their beliefs idly, and their conduct is not the outcome of any perversity. Just see, my lords, how beautifully it is put. They do not hold their beliefs idly, and their conduct is not the outcome of any perversity. The petitioners have not asserted these beliefs for the first time out of any unpatriotic sentiment. Jehovah's Witness, as they call themselves, appear to have always expressed and stood up for such beliefs all the world over, as we shall presently show. Lord, it is not a case where somebody comes up with a shawl and says that, look here, that I am asserting my right. This is a case, my lord, where the students have been wearing their headscarf for years together. And then, my lords, may kindly see how the court deals with this. First, my lord, the court says in paragraph 14 that the circulars which the state relies upon, that can't be the basis of restricting this freedom under Article 19(1)(a). And that's going to be my second limb of submissions, but just make a note of this at page 84. The argument which I am going to make, a college development committee has no statutory basis. It is not formed under any statute. It is done under some circular, which according to me does not pass the muster, my lord, of restricting public order. But that argument, kindly see, my lord, at page 14, paragraph 14, page 84. Apart from the fact that the circulars have no legal sanction behind them, in the sense that they are not issued under the authority of any statute, we also notice that the circulars do not oblige each and every pupil to join in the singles, even if he has any conscientious objection based on his religious faith. On the other hand, one of the circulars very rightly emphasized the importance of religious tolerance. It is said that all religions should be equally respected. If two circulars are to be interpreted as to compel each other and every people to join in the singing of national anthem despite his genuine conscientious religious objection, then such compulsion would contravene rights guaranteed by 19 and 25. Then, my lord, the question which fell from my lord Justice Dikshit, lord, as to what is law, etc., that, my lord, is answered over the page at page 85. I will not trouble your lordships with that right now. And then, my lord, kindly turn to page 86 in the context of Article 25. Page 86, paragraph 19. The last 4 or 5 lines from the bottom of that paragraph. Therefore, when the fundamental right of freedom of conscience and to profess, practice and propagate religion is invoked, the act complained of as offending, kindly see this, my lord, the act complained of as offending the fundamental right must be examined to discover whether such act is to protect public order, morality and health, and whether it is to give effect to the other provisions of Part 3 of the Constitution, and or whether it is authorized by a law made to regulate or restrict any economic, financial, political or secular activity which may be associated with religious practice. This is the test which they formulate.
Please read further. Complete.
I'll read it. I'll read the whole thing, my lord. It is the duty and the function, I'm grateful now, it is the duty and the function of the court to do so. Here again.
No, before that you will skip the first 6 words.
I'll read the whole thing, my lord.
So may be associated with the religious practice.
Yes, I'll read that, my lord.
Or to provide for social welfare and reform. These words.
Yes, I'll read it again, my lord. By a law made to regulate or restrict any economic, financial, political or secular activity which may be associated with religious practice or to provide for social welfare and reform. I'm grateful, my lord, that a law providing for social welfare and reform definitely, my lord, is a restriction under Article 25(2) on the fundamental right. So the question will be, my lord, where is that law which provides for social welfare and reform, on the basis of which, my lord, this headscarf today is said to be prohibited? And as far as 25(2) is concerned, my lord, the submission is that a college development committee has no statutory basis. I'll come to that, my lord. Now see, my lord, on 25(2), what should be the approach of the court? Page 88, my lord. At this I commend, my lord, for my lord's consideration.
Can you articulate the ratio of Bijo Emmanuel?
Yes, my lord. Lord, yes. After completing this, can I put it into 2 or 3 compartments? My lord, that's my.
Now you had read, loudly read Bijo Emmanuel.
Yes, my lord.
So what is the ratio emerging from this?
The ratio, my lord,
restrictive power of the state in the light of para 19.
Yes, my lord. My lord, in the light of paragraph 19 and other paragraphs, my lord, 2 things according to me flow out, my lord. One, that of course the state has the power to, my lord, regulate economic, financial, political or secular activity with a religious doubt about it. At the same time, if there is
no question is,
yes,
appreciate.
Yes.